Hey guys, Mikey here. Real quick, I just want to give you a rundown on this case. I missed just a tiny bit at the beginning. It's a rundown that the man that's incarcerated had went to an adult dating site, met someone. That person then claimed to be 15. They engaged in some chit chat. Uh, Turned out the person that was claiming to be 15 was doing to catch a predator type deal on their own, as the judge later calls it, vigilante justice. Um, that's pretty much the rundown of it. And you have all the details of the case coming up now.
Scheme of his, he used not only his real birthday, which is 20, which would make him 25, but also when you create a Tammy profile, you have to upload a current selfie of yourself. And this is not something that you can upload from a phone, from your camera roll or anything else. You have to take it using the camera function itself, which means it has to be current and has to be immediate. And so Mr. Hutchinson, when creating this profile, which he allegedly met Mr. McLean on, created a profile of himself as he is himself, a 25-year-old male. And this is the initial point of contact between Mr. McLean and Mr. Hutchinson. And Mr. Hutchinson was very clear in his statement to police that he never used any other pictures other than himself. And so when Mr. McLean and him were exchanging information on Instagram, Mr. McLean had already seen him as he was, which is a 25-year-old individual. Now, Mr. Hutchinson's Instagram profile that he used, it's unclear because it's deleted exactly what the picture was that he had, but it was assumedly a picture of himself. And so whether or not it was a younger picture of him being 17 or 18, Mr. McLean had already seen Mr. Hutchinson as himself, which is a 25-year-old individual. And if we look at Mr. Hutchinson now, I know Your Honor probably hasn't reviewed, but he does have a beard. He looks like a 25-year-old. And so it makes really no sense in terms of an individual being able to put a selfie of himself as an older person and then go backwards, as opposed to someone who is like this is how Mr. McLean saw him. And so Mr. McLean in the initial conversation saw him as a 25-year-old individual. And while we look at these text messages, while it's clear that he said that he was a 15-year-old, there are many contexts within these text messages that indicate that Mr. McLean did not actually reasonably believe he was talking to a 15-year-old, but was talking to someone who is pretending to be a 15-year-old for perhaps whatever sexual fantasy Mr. McLean and Mr. Hutchinson prefer to be in. There's a frequent refer to them as calling each other daddy, which is often a sexual fantasy within queer relationships. At one point, Mr. Hutchinson said he's going to Uber from Gloucester to Mr. McLean's house in Vineland, to which Mr. McLean responds, "You must be rich," which indicates that no 15-year-old can afford an Uber that far, and that again, there is something here that shows that he is not indeed a 15-year-old. Additionally, there is a phone conversation that happens between the two, where Mr. McLean hears Mr. Hutchinson's voice on the phone, recognizes that it is not the voice of a 15-year-old, and comments that to him and says, "You don't sound like a 15-year-old," which Mr. Hutchinson said in his statement. And so given all of this, given that there is consistent questioning of whether Mr. Hutchinson's pictures are recent, given that he heard his voice, given that he initially saw him on a dating site that is 18 plus, had him as a 25-year-old, this is all indication that Mr. McLean did not reasonably believe that he was talking to a 15-year-old, but talking to someone who was a 25-year-old as he presented him, pretending to be a 15-year-old for some sort of sexual fantasy between the two of them. And additionally, as Ms. McGlynn pointed out, there was a conversation of, "I don't want your friend to see you." That could potentially be, "I don't want my friend to see me hooking up with someone else." We don't know exactly whether or not this is because he believed it was a 15-year-old, or rather because he just didn't want to see someone hooking up. We don't know exactly what it is. It's not clear from the text messages, particularly that he's attempting to specifically solicit sex from a 15-year-old, or say specifically, "I want to have sex with you because you were 15. And so there is clear evidence, especially from the initial meeting point, that this was not someone who Mr. McLean reasonably was a 15-year-old. Additionally, in terms of the luring and enticing standpoint, the complaint itself charges Mr. McLean with luring and enticing Mr. Hutchinson to a Walmart. Now, that location was at the offering of Mr. Hutchinson. Mr. Hutchinson, both initially beforehand, suggested a Walmart or another public location. When Mr. McLean said, "I don't want my friend to see you," he was the one who proffered the Walmart. And so again, luring and enticing to meet or appear at a location, Mr. McLean did neither. He did not lure or entice Mr. Hutchinson to appear at the Walmart. He himself responded to Mr. Hutchinson's suggestion of that meeting place. And so again, the luring and enticing portion of this statute is not met. Your Honor, there is significant concerns regarding the underlying facts of this. As Ms. Glynn pointed out, there is concern about what occurred and what went down when they did meet up, including an assault, which Mr. Hutchinson acknowledged in his statement as well. And so given that this was essentially built upon a lie of Mr. Hutchinson claiming to be a 15-year-old when he gave every indication to Mr. McLean that he was not, and that the ultimate place where they met was at the suggestion of Mr. Hutchinson, we would submit that the state has not met its burden for probable cause, even though that is a relatively low standard.
Thank you. As to the probable cause, I would note that the offense is charged under 2C13-6, which indicates a person commits a crime of the second degree if he attempts via electronic or any other means, which we have here, to lure or entice a child or one who he reasonably believes to be a child to meet or appear or any other place with a purpose to commit a criminal offense with or against the child. And the argument by the defense is that the state's unable to prove probable cause that the defendant reasonably believed this person to be a child. I would acknowledge that the arguments advanced by the defense are valid arguments and ones that ultimately do undermine some of the strengths of the state's case. The circumstances of this are very odd. You would have a layperson do this to begin with. But based upon the plea, the complaint, the affidavit of probable cause, as well as the recitation, the state is able to meet the low standard that there is probable cause that exists that the defendant engaged in a violation of this particular offense. And there certainly is enough in the record wherein Mr. Hutchinson, referring to represented himself to be a 15-year-old, made certain statements about being underage. I think he said he couldn't drive or something along those lines. So there is enough there to establish probable cause. So I do find probable cause. Prosecutor, though, even though there's probable cause, why can this defendant not be released?
Thank you, Judge. The defendant scores a 3 on the failure to appear risk scale and a 4 on the new criminal activity risk scale. And he has 7 prior disorderly persons offenses, including a simple assault from 2020 and some years prior, including another simple assault, resisting, obstruction, and hindering. He has 1 prior indictable conviction for aggravated assault with a deadly weapon.
I don't mean to interrupt. I'm looking.
Sure.
I'm just looking at the PSA. I didn't see a 2020 charge. The most recent I saw was 2009. So maybe I missed.
No, that could be me misreading. Let me look. Oh, I'm seeing in the disorderly persons, it says Cumberland, and the PG number is 2023-24, and then with an offense date of 11/25/2020.
You're looking. Are you looking at the PSA?
Yes.
All right. I'm sorry. I keep. And what section is it in? DP prior to conviction.
Mm-hmm.
All right. So the top one I see is November 4th, 2009. Maybe I have the wrong one open. This.
And then all the way at the bottom of that, for whatever reason, it says.
That's why I missed it. It's not in order. Thank you. Okay, I see it now.
The There are 3 prior temporary restraining orders in his history, all 3 of those having been dismissed, and the most recent one of those was from 2024. The PSA does recommend that defendant be released on level 2, but the state submits that defendant should be detained. The state would assert that the weight of the evidence, although the case is, from a strange set of circumstances, it's strong evidence, specifically the defendant giving a statement to law enforcement that he was told the person he was talking to was 15. He continued talking to him anyway. He made the conscious decision to meet up with him at the Walmart. He was given all of the messages to read through in his interview, and he said that he was familiar with them. So the messages speak for themselves, and they show defendant's clear intent to meet with someone who he believed was a 15-year-old boy so that he could have sex with them. I don't have the information that Ms. Lamont has about the Tammy app, but that was not my understanding of the app. So regardless, the state's assertion is that defendant's intent to meet up with this person he believed was 15 for the purpose of having sex with him is pretty apparent. And defendant also said in his interview that the 15-year-old boy was, or who he believed was this person, was pressuring him via message to meet up, which is a moot point because defendant, as a 40-year-old man, could have and should have just blocked this person, but he didn't, and he met up with him. So all of those factors contribute to the strength of the state's case, and inherently create the risk that defendant may not appear to face a serious charge where he's facing a maximum sentence of 10 years in state prison. Judge, while the state doesn't condone or endorse vigilante style investigations, and situations like this can pose safety risks and complicate legitimate law enforcement efforts, the fact remains that the defendant's own actions, his decision to pursue, contact, and appear in person and meet with this person who he believed to be 15 demonstrates a clear danger to the community. He believed he was communicating with a 15-year-old, and despite his age, he chose to continue those communications and ultimately traveled to meet him. Whether or not this person was actually 15 doesn't matter when the defendant had the intent to meet up with a child. This behavior reflects a willingness to engage in conduct that directly targets children by someone who does have a criminal history that includes violent charges. And this behavior has also shown that the defendant, despite displaying an awareness that this conduct was wrong, took the steps to engage in sexual conversation with the intent to engage in sexual conduct with a 15-year-old. So this all underscores the need for detention, for protecting the safety of the community. For those reasons, the state respectfully requests that the defendant be detained.
Prosecutor, I just want to understand the statement a little clearer. You said that he acknowledged that the person said that he was 15. Did he
Yes.
acknowledge that he believed the person to be 15, or just that the person said that he was 15?
The defendant was a bit vague as to whether or not he was proceeding, like he was a bit vague as to those underlying circumstances, but he was asked multiple times by the officer, why did you meet up with him when he was 15? Because I'm lonely and I don't have a lot of friends. He didn't say, well, he never really said much in his interview, I thought this guy was 15, I had sexual or I thought this guy was an adult, we had sexual fantasies, whatever. All of those things would explain away the circumstance that he's in now. But he said, yeah, I continued talking to him after he said he was 15. Yeah, I went to meet up with him. So that's really the main demonstrating point of the defendant's intent in wanting to have sex with a child.
Understood. Thank you, prosecutor. Ms. Lamont?
Thank you, Your Honor. I would just like to address that last point. First, in terms of Mr. McLean's straightforwardness with the police, he is not required to answer any questions by the police. And so in terms of him and his unwillingness to be straightforward with the police should not weigh in Your Honor's concern. I understand wanting to clarify the statement, but as Ms. McLean and the state have pointed out, he never said, I believe this person was 15 and I wanted to have sex with a 15-year-old. That was never said. That was never said to the police. And what could be inferred from his lack of, or his vagueness as the state classifies it, is an unwillingness to talk with police who we've never talked to before about his sexuality, about his sexual fantasies. That we would submit is a very natural thing to be withholding about, to have certain desires to not share a recorded interview with. And so it should not weigh against Mr. McLean that he did not delve into or explain away, to use the state's term, why he wished to meet up with Mr. Hutchinson and exactly what his intent was and exactly what his belief was. So that is one reason, one thing for Your Honor to consider to counter. Additionally, I would like to address the state's contention that this individual targets and seeks out sex with minors. First off, in his record, there is nothing that indicates that at all. I understand the state's contention that the facts are the facts. The facts are also the facts, and the fact that Mr. McLean met this individual on Tammy, which is a legitimate dating app. This is not some dark web site that exists for individuals to solicit specifically sex from underage individuals. That was not where they met, and then they exchanged conversations on Instagram. And that, again, is a legitimate website. So this is not some backdoor dark web website where Mr. Hutchinson was on to try and find people who have certain predilections to have sex with underage individuals. This was a dating app that is designed to be between consenting adults. And that is where Mr. McLean was reached out to by Mr. Hutchinson. And again, it's important to note, I don't want to reiterate too much of the facts that I spoke about in the probable cause argument, but this was an instance of Mr. Hutchinson reaching out to Mr. McLean and trying to entrap him in this essentially vigilante scheme to satisfy his own kicks. This was not Mr. McLean reaching out to individuals he believed was to be 15. This was Mr. Hutchinson doing it, Mr. Hutchinson posing as a 15-year-old, which should raise significant concerns to the state in terms of an individual pretending to be a younger person for many things. What Mr. McLean would have done in terms of blocking this account is not a crime. We cannot judge Mr. McLean for what we in his position would have done, but rather whether or not he committed a crime. And I would submit again, Your Honor, that he did it, and that he reasonably believed that this individual was not 15 for the multiple reasons that in the information I take from Tammy was not from personal views, but from what Mr. Hutchinson said he himself did, which was he took a selfie of himself and put it on the internet as a 25-year-old individual. That is Mr. Hutchinson's own statement. And again, Mr. Hutchinson's own statement is that he specifically wanted to meet up with Mr. McLean at a Walmart and specifically threatened he would call the cops if Mr. McLean did not let him slap him 3 times in the face. This individual, for a myriad of reasons, the state has significant issues, both with the evidence, but also with the person bringing them the evidence. This individual has established significant credibility issues on the very grounds that he himself is a liar and brought this forward under lies and under a vigilante attempt to enact his own sense of justice, and is using the state's prosecution office and the police as his own personal tools to carry that out. That is a significant concern to the to this court, and also in terms of a concern for public safety, much more so than Mr. McLean, who has never indicated that he has any interest in pursuing sex with underage individuals, and himself was not found on an app or dating website or website of any kind specifically designed to do that. And so in terms of the state's characterization that Mr. McLean is somehow attempting to solicit sex and that this is his predilection and he's a threat because of that, the facts don't support that, either in his record or in the facts here of how Mr. McLean and Mr. Hutchinson came to know one another. So, Your Honor, we would submit that he is not a threat for public safety in any way. And turning to his PSA, I looked at the 2020 conviction. It was downgraded in 2021. There's no disposition date. Unclear why. I mean, that was right before COVID hit, so there's a myriad of reasons as to why perhaps this got lost in the system, and there isn't a disposition in terms of this charge. But again, even if we were to go to 2020, that is 5 years ago. That is quite a while for Mr. McLean not to pick up any new charges. And the rest of his record is extremely dated. Your Honor, he hasn't had a violent conviction since 2006 or really a disorderly person conviction since 2020. And so in this sense, his record is extremely dated. He's not displayed any sort of indication that he is going to repeat criminal behavior. Additionally, his indictable from 2006 was when he himself was 26. And so there's evidence that from the age of 26 to the age of 42, he has grown and changed significantly and has essentially gotten his life together, more or less. And so the age of that conviction should weigh heavily in Your Honor's consideration of whether or not we want to hold an extremely dated conviction against Mr. McLean for purposes of determining whether he's a threat to public safety. Again, he has one FTA from the past in his entire history. That was from 2009. So again, it was before the CJR statute was enacted, which means he's never received the benefit of pretrial monitoring. So everything in his history indicates that he does come to court, and that with the extra imposition of conditions of pretrial monitoring, we would submit level 1 would be sufficient, but level 2 is recommended. That would ensure he would come to court. Your Honor, I would submit that Mr. McLean has no interest in contacting this victim, has no interest in any sort of further communication with this individual, and that with the ability to be on pretrial monitoring, he will come to court. There is a PSA recommendation that he be released with conditions bi-monthly reporting. We would submit that even level 1 would be sufficient to ensure that he comes to court, given his relatively dated record, the significant concerns for the weight of the evidence and the ability for the state to bring and convict on this case, and again, his lack of failures to appear. And with that, we'd ask that you follow the recommendation of the PSA and release him with the appropriate.
What's his personal circumstances? Where's he living? Is he working? What's he doing?
So Mr. McLean, he owns his own home. So he, as was noted and in the record, he is a homeowner. So he has a stable place to live. He's lived there for 4 years. He is currently on SSI. He has disability, so he receives disability payments to support himself. His brother is in the area who also supports him as well. So he has family in the area. He has, Your Honor, just to proffer by way of investigation, he has been struggling with alcohol dependency in the last couple of years. And so our office stands ready and willing, and we've talked to Mr. McLean about this, about connecting him with programs so that he can get the treatment he needs while he continues to resolve these charges moving forward. But he's a high school graduate. He's been in the area his whole life. So he has deep community ties. He has a home here that he can receive mail at, so to ensure that he is getting notices. And he has income from the government as well as family in the area to support him.
Thank you. As to the next analysis as to whether or not the state's able to establish by clear and convincing evidence that the defendant should be detained, the court considers a number of factors. First, the court places significant weight on the public safety assessment. This public safety assessment gives him a 3 on a scale of 1 to 6 on failure to appear and a 4 on the risk of new criminal activity. And it does make a recommendation that he be released on level 2. I would note that he is 42 years of age. The present offense is a first-degree offense. Strike that, is a second-degree offense for luring. That offense does carry with it significant exposure, up to 10 years if he were to be convicted of it. There are certain proof issues that the court finds, and the court does place weight on the weight of the evidence that the state has in this case. There's a lot of conclusions that are drawn in the state's argument as to its proofs in this case. The vigilante justice is, the court finds, is certainly a different way for a case to be brought to court like this, and it does somewhat undermine some of the state's proofs, especially the odd behavior of the alleged victim in this case, saying, I want to hit you or strike you a few times. That just strikes the court as very bizarre, and it causes the court to sort of question some of his credibility in this as well when it's all said and done, and something that'll be presented to the jury. So I don't find it to be the strongest of state's cases, and I do take that into consideration. As to his prior criminal history, there is this 2020, it says 2020 offense date, November 25th, 2020. As far as disposition date, there is none. So as I sit here today, I look at this as an offense to which the defendant's been charged and not convicted. So I don't place any weight in this 2020 allegation. So I look back at his most recent contacts with the criminal justice system, which date all the way back to 2009. So they are significantly aged. What is that, 15, 16 years ago? My math's correct. Yeah, 16 years ago. So, and those are just DP offenses. There's a couple from 2009 and a couple from 2006. So for this court's analysis, he's led a relatively law-abiding life for a significant period of time. He does have that one prior indictable conviction, which also dates back to 2006 because of the age of it. 19 years ago, the court does not place much weight in that. And the same with the prior violent convictions. I would note that the violence we're talking about is his ag assault on a police officer. I'm not even sure what degree it is. It says I. I'm not sure exactly what that is, but it would have been, I guess that's what it says, I. And then he's got the two simple assaults, which are disorderly persons offenses. So as far as his prior contacts, they're minimal at most, and they're certainly aged. He has a prior failure to appear from 2009. I don't place any weight in that, and there's no reason to believe that he would not appear in court when required to do so based upon his history. He has had some prior sentences to incarceration. Looks like he just has 19 days. Pretty odd that in 2006 he received 19 days, and in 2009 he received the same 19 days, but that's what it reflects. So he's had minimal periods of incarceration. As far as his personal circumstances, as the defense indicated, he's a homeowner, so he clearly has ties to the area because he has a home in the area. He receives SSI, so he has a source of income. I guess he's receiving SSI for some particular reason as well. And he's got I think a brother in the area as well. So he does have ties to the community. So ultimately, the state would need to prove by clear and convincing evidence that there's a likelihood that he would not appear in court when required to do so. I don't find that based upon his ties to the community, his lack of any history for his failure to appear in court. I don't find the state's able to meet that burden of proof. The state's argued he's a risk to the community. I don't find the state's able to meet that burden of proof either. His contacts, his criminal contacts, as I've indicated, are aged. And there's been some argument by the state that the nature of these circumstances indicate that he's a risk to the community. I don't accept that argument. I would note that even the site that he went on, as the defense had argued, was not is a regular dating site that he went on to. If he were engaging in activities and going to areas to engage in this activity that were illegal or suspect in nature, maybe there's an argument that he's regularly engaging in this type of behavior, which would cause someone to believe that he is a risk to the community at large. But going on to a regular dating site and engaging in this activity undermines the argument that he is a risk to the community. So I don't find that the state's able to meet its burden of proof as to that, and nor do I find any risk that he's going to obstruct justice in this case. There's nothing in his record that would suggest that. So based upon a balance of all those factors, I do find that the state's unable to meet its burden of proof, and accordingly, the defendant should be released. As to the conditions of release, I concur with the public safety assessment recommendation that he be released on level 2 reporting. All standard conditions should apply. My intent, Ms. Lamont, unless there's an objection, is to indicate, and I don't know his personal circumstances, that he should not have any contact with minors, and that's just out of an abundance of caution. Would you object to that condition? Is there any minors in his that he regularly, family members that he regularly is with, that would be of a concern with that condition?
Not to my knowledge, but can we just see if Mr. McLean is able to answer that question himself?
We just have to unmute him. Mr. McLean, any issues with regard to condition of not having contact with minors?
No.
Okay, very good. So that'll be a special condition. Prosecutor, are there any other special conditions that you believe are appropriate in this case?
No, Judge, as you noted before, the alleged victim and the defendant are not known to each other, but I guess standard conditions, just no contact with the victim.
Any objection to no contact with the victim, Ms. Lamont?
No, Your Honor.
That'll be included as well. Brittany, I'm sorry, you had a question, sir?
I don't know him at all. I
Okay,
never met him in my life.
Yeah, don't worry about it. Yeah, you don't want to talk to him anyway, so no, so don't worry about it.
Brittany, anything else to be included as part of this release order?
No, Judge, everything's covered.
All right, very good. And he has his pick date scheduled?
Yes, and Judge, if we can just let the defendant know that he will need to report Monday morning by 11 o'clock a.m. to pretrial services.
Got that, sir?
Where is that?
You can actually call, sir. The information will be at the bottom of your release order for the telephone number and extension to call. Just make sure you read over your release order.
I just need to call.
Yes, you just need to call by 11 o'clock on Monday morning.
Okay. Am I getting mailed the paper?
Yeah, no, they'll give it to you before you're released from the jail. They'll hand it to you.
Okay.
Okay. And Judge, is it just standard conditions? I know it's no contact with minors, but are there any other conditions? No new offenses, obviously.
Just the standard, right? No, the
Okay,
standard, no new offenses, right?
okay, got it.
Understand? Because I never knew this man. Never
Understood.
met him in my life.
Brittany, anything else we need to address?
No, that's it.
Thank you, sir. Brittany, how about you? Anything else we need to address? You're on mute.
Sorry, I was muted and talking. Do we tell him his pick date? His pick date is scheduled for December 18th before Judge Chiarello.
That's your next court date. So December 18th at 9 o'clock before Judge Chiarello. Pretrial services, we'll discuss that with you as far as making sure you're aware of the date and where to go and those types of things.
Okay.
And then also, Judge, will verify, since we're not allowed to verify on the record the defendant's address or any information due to the scam that was going on, when you call in to report Mr. McLean, just make sure that you provide any updated contact information that you need to provide to pretrial. That's all, Judge.
Very good. Prosecutor, anything further?